So welcome back, and let's continue with the second part of week two's lecture series. So we'll do partners' rights, obligations, and liabilities. This is in reference to a partner's obligations and liabilities, not just with third persons but also with the partnership. Yeah, so let's start. Now, partners' rights. Under Article 1810, it explicitly enumerated three. The property rights of a partner are his rights in specific partnership property, his interest in the partnership, and his right to participate in the management. Now, these are property rights. That's why they're enumerated under Article 1810. Now, there are other rights that a partner has as well. These are five other related rights. So these are not property rights. For example, under 1796 of the Civil Code, there is the right of reimbursement for advances and indemnification. Number two, a partner's right of inspection under Article 1805, which we will discuss later also. Number three, the right to true and full information of all things affecting the partnership under Article 1806. Number four, the right to a formal accounting under 1809. And number five, the right to have the partnership dissolved under certain conditions under Articles 1830 to 1831. So, with the exception of number five, the right to have the partnership dissolved under certain conditions, I will already discuss the first four later. But before anything else, we'll proceed with specifying or discussing the property rights of a partner. So we move on to Article 1811. A partner is co-owner with his partners for specific partnership property. The incidents of this co-ownership are such that 1. A partner, subject to the provisions of this article and to any agreement between the partners, has an equal right with his partners to possess specific partnership property for partnership purposes. So number 1 talks about possession. It says that it is only for partnership purposes, but it can be for another purpose as long as there is the consent of the partners. Now, they can also make an agreement different from what is stated here. As it's mentioned here, subject to the provisions of this title and to any agreement between the parties. So this is just the general rule. Number 2, a partner's right in specific partnership property is not assignable. So number 2 talks about assignment, except in connection with the assignment of rights of all the partners in the same property. The reason for the exception is because if all the partners assign their specific rights over the same property, then the co-ownership is acting together as one, no? And when you say this, an assignment by all the partners over specific partnership property is actually an assignment by the partnership, because literally the partnership cannot make an assignment, cannot sign, because it's not a human being that can sign over a piece of paper. It's really done by the act of its partners. Now, the same with number 3 pala, excuse me. A partner's right in specific partnership property is not subject to attachment or execution. So, by attachment or execution, we are referring to an attachment or execution done by an individual partner's creditors. So, the exception here states that the one who can attach or execute specific partnership property is, of course, the partnership's creditors, because the property is owned by the partnership. So, when the partnership property is attached for a partnership debt, the partners or any of them or the representatives of a deceased partner cannot claim any right under homestead or exemption laws. Now, just briefly, there are certain pieces of property that cannot be subject to attachment. So one thing I can remember at the top of my head is family home cannot be subject to attachment. And if I'm not mistaken, a business, if it is the only source of livelihood. I may be wrong there. But anyway, number four is a partner's right in specific partnership property is not subject to legal support under Article 291. Now, why is that? Because legal support is actually an obligation of a parent or a spouse to their other spouse, no? So, of course, because a partnership cannot get married or have kids, it cannot be subject to support. Basically, the entire provision is just an implementation of Article 1768 that states that a partnership is a separate juridical entity. Therefore, pieces of property owned by the partnership are separate from the properties of the individual partners. Now, what is actually a partner share in the partnership? If 1811 limits a partner's rights over specific partnership property, what does a partner have complete control over? It's actually found in the next provision, 1812, where it states that a partner share is only in the profits and surplus of the partnership. Okay. Now, you may ask, why is there a specific provision under 1811 for co-ownership when, for those who may be familiar, there's actually an entire section in the Civil Code for co-ownership. Now, 1811 is an exception because the rules of co-ownership under the other section of the Civil Code does not apply here. Okay. Now, when the article talks about co-ownership, as I've mentioned, it's not over the partner's interest in the partnership itself, since it's under 1812. What happens in number one if a partner possesses the property and uses it for another purpose without the consent of his partners? In the event that the partner violates the last sentence of number one, this one, in the event that the partner does not use it properly without the consent, then please note that under Article 1807, it is a partner's duty to account for profits for use other than partnership purposes. It might fall there. Now, if, for example, if someone is wrongfully excluded to possess the partnership property, meaning each partner has a right to possess the property for partnership purposes. In the event that he's excluded wrongfully, meaning there's no reason to exclude him, then he can now request for a dissolution. And he can also ask for a formal accounting. And we will discuss that later under Article 1809 because that's one of the partner's rights. Okay. Now, when you talk about assignment, under number 2, this is to prevent interference of outsiders in the partnership's affairs. This is different, and we will discuss this later on when we go to dissolution, where a retiring partner can assign his rights to the partner or partners continuing the business. So that's different from 1811 number 2. So just take note, this is different. 1811 number 2 is different from Article 1840 numbers 1 and 2. Okay. So let's proceed to Article 1809. Any partner shall have the right to a formal account as to partnership affairs. And there are 4 instances when a partner can exercise this right to a formal account. Number 1, if he is wrongfully excluded from the partnership business or he is wrongfully excluded from possession of the property by his co-partners. Number 2, if the right is explicitly stated under any agreement, not just the articles of co-partnership, meaning they can agree to it after creating the partnership, that they can ask for a formal account at any time. Number 3, as provided by Article 1807. And 1807 talks about instances where a partner must account for profits it makes without the consent of other partners. Yan. So, but we will discuss that when we go to partners' liabilities and obligations. And number 4, whenever other circumstances render it just and reasonable. Now, on Article 1809, it is said, is actually an exception to Article 1805 and 1806, where, if you remember Article 1805, it talks about our partner's right to inspect the partnership books at any reasonable hour. And Article 1806 talks about a partner's requirement to render on demand true and full information of all things affecting the partnership. Now, why is it an exception? Because if you remember what we discussed in the first video, by virtue of 1805, a partner is presumed to know the state of the partnership and its financial state and its viability. So, if a partner is presumed to know, therefore there is no more need for a formal accounting. That's why this is the exception to 1805. Another exception is that this is actually different from the general rule that that a formal accounting is only done upon dissolution. That's why there's 1809. This is actually, if you look at the especially number 1 and number 3, this is actually to promote transparency. So, but it doesn't mean that this right is only exercised when the partner is wronged. So, like for example, number 1, he is wrongfully excluded. Number 3, if another partner earns without the consent of the other partners. Number 4 does not necessarily require that a partner is wronged. In De Leon's book, he gives an example where a partner is abroad for a long period of time. So, that partner who's abroad is not able to access the books of the partnership. And, given that books are voluminous, especially for future accountants like you will see this when you do audit. Syempre, the partner who comes from abroad would want a summary. That's why he wants a formal account. Now, to be more realistic, given the pandemic now, the partners cannot even see each other. It's possible that they venture into an online business and the partners have their own transactions with customers. Diba? For example, if you're in the food business and you're doing this with your partners, you have a commissary in another place and you're just working from home, taking orders and contacting the commissary. So, of course, everyone has their own books and you need to consolidate. So, syempre, the partners would like a formal account just to make it clear na each partner is earning this much. Yan. So, that's a more relevant example for number 4. Now, under Article 1804, this talks about a partner's interest in the partnership, and it does not refer to a particular piece of property. 1804 states every partner may associate another person with him in his share. So let me just emphasize his share. But the associate shall not be admitted into the partnership without the consent of all the other partners, even if the partner having an associate should be a manager. Now, this is because, and as we've mentioned during the first video and the video under week 1, a partnership is a fiduciary relationship. So the fact that, say, A, B, and C company, the fact that A assigns his entire share to someone else does not mean, say, for example, to X, an outsider, it does not make X a partner. Otherwise, X will be imposing himself as a partner to B and C. What if B and C don't like X? What if B and C don't know who X is, diba? So, that's why there is a need for this provision to be clear. Now, this provision talks about a sub-partner, which we have also discussed in the first week. To me, it seems like a misnomer because you're calling that person a partner, sub-partner. Pero technically, he or she is not. No? So, because the person is not a partner, technically, in the truest sense of the word, this sub-partner does not have the same rights as the original partner. That's why a sub-partner has rights under Article 1813, which we will discuss right after this. So, the fact that someone assigns does not make the sub-partner a partner without the consent. Now, it may lead you to ask, what if all the partners know? Say, in A, B, and C company, B and C know that A assigned all his rights to X. Does that make X a partner? No. Because, in this case, we're talking about consent, not naman ratification. A is free to do whatever he wants with his share. And B and C can just look. But it doesn't, when you say consent, B and C are clearly saying, okay, we will make X our partner. If the partners, say B and C, were to accept X as their new partner, there is a modification of the partnership. Because of this modification, De Leon states that even if the assignee is a current partner, there is still a need to have the consent of the others. For example, A, B, and C company. If A assigns all his shares to B, B will only have a secondary right to A's share. It will not be a partnership between B and C alone unless C consents and says, okay, we'll take A out. Now, this is the practical application of that view by De Leon is because it's possible that C might not want B to have controlling interest over the partnership. That's why C would still want to keep A. A sub-partner's rights is not the same as the rights of a partner because the sub-partner is really not a part of the partnership. He's just after the share of the one who's assigning their rights to the partnership. In the previous example, A. Now, this is why there is Article 1813. It clearly states that a conveyance by a partner of his whole interest in the partnership does not of itself dissolve the partnership, or as against the other partners in the absence of agreement entitle the assignee during the continuance of the partnership to interfere in the management or administration of the business. So the sub-partner cannot also require any information or account of partnership transactions. The sub-partner cannot inspect the books. It merely entitles the assignee, or let's just say the sub-partner to make it easy, it merely entitles the assignee to receive in accordance with his contract. When you say his contract, his agreement with the original partner, so in that case, A and X, he is only entitled to receive the profits, which the assigning partner would otherwise be entitled. However, in this, an exception to the rule, meaning a sub-partner can exercise the rights of interfering with management, the right of requiring information, or the right to inspection. He is entitled to that if there is fraud in the management of the partnership. This is because he would naturally want to take care of A's share in the profits kasi that's going to be his. Okay. In case of a dissolution of the partnership, the assignee is entitled to receive his assigner's interest and may require an account from the date only of the last account agreed to by all the partners. What does this mean? As I've mentioned before, a formal account or a formal accounting is done upon dissolution of the partnership. So, the assignee here, in this case X, is entitled to receive A's share in the partnership upon dissolution, and he may ask for an accounting of A's share to make sure that he really got the proper amount. But there's a qualification. Only of the last account agreed to by all the partners. What does it mean? During a dissolution, the partners can actually ask for a formal accounting. So it does not give a particular time. It is a right given to them. Now, the sub-partner does not have that right, meaning whatever A, B, and C agree would be the last date of the formal accounting is the only formal accounting that he can get. He cannot later on ask for an updated one. Yeah, that's all this last paragraph means. Let's move on to Article 1814. Now, 1814 talks about the rights of a partner's judgment creditor. This is different from Article 1813 because 1813 refers to either an assignee or a purchaser of a partner's interest. Here, 1814 talks about, as I mentioned, judgment creditor. Meaning there has to be an order of the court. It cannot just be any other creditor. Now, if you read the provision carefully, it talks about charging the interest of the partner with the payment of the judgment debt with interest. And a receiver may be appointed to receive the debtor partner's share of the profit or any other money that may fall due to him. And also, the receiver can also exercise some of the debtor partner's rights. Particularly, the receiver can make inquiries or ask for an account, no? Now, please don't mind this. It's a repetition of the same sentence. But the second paragraph, it states that the interest charge may be redeemed at any time before foreclosure. So the second paragraph talks about redemption, either foreclosure or sale. And the redemption will not cause a dissolution. Now, who may redeem? It may be with a separate property by any one or more of the partners, or the partnership property can be used to redeem. But if partnership property will be used, it must be done with the consent of all the partners whose interests are not so charged, meaning the partners excluding the debtor partner. Okay. Now, this article talks about a charging order. No specific property is attached here. We're just talking about A's share, which is share in the profits and surplus. Since we've already discussed countless times, or I've already mentioned countless times, that a partner's share in the business is his or her own property. So, he or she is free to do whatever he or she would like, and it will not change the partnership since the one who will be assigning, the assignee or the purchaser will not be a partner anyway. Why is there a need for this provision pa? Because this provision gives specific, exclusive remedies that a creditor can take. Normally kasi, for other cases where there is a judgment creditor can since it's already equipped with an order of the court telling a person to pay the creditor. Say for example, the court says, A, you are hereby ordered to pay X, the amount of 100,000. If A does not pay, then the creditor can usually attach property. It can garnish bank accounts, have it garnished with the help of the sheriff, or it can, and this is done by a writ of execution. Now, because there is 1814 for partnership, then the judgment creditor does not have a right of a writ of execution because 1814 creates its own remedy. In this case, a judgment creditor can ask the judgment court or any court to charge the interest of the debtor, and the court can now appoint a receiver if needed. Now, the next question, why are there specific provisions for redemption? Because normally, only the debtor can redeem. Because in this case, for example, if A's share was charged by the court for the interest of for the benefit of X, then if A's share is subsequently sold, say in a foreclosure sale, only A can redeem the property back. But 1814 makes an exception. It says here that the property A's share can be redeemed either through the separate property of other partners or using partnership property as long as all the partners consent. When you say all the partners, excluding debtor partner, actually gives them a chance to maintain the relationship. If you're looking at the practical side, if A's share is actually foreclosed, it means A does not have any more money. That's why A's judgment creditor ran after A's share in the business kasi A doesn't have other property outside of the business anymore. So, in that case, usually, the other partners will redeem and give A the chance to pay them instead. Otherwise, the partnership will be dissolved. A will be removed from the partnership. Now, there's a similar, not identical, provision about it, talking about discharging order for limited partners, which we will discuss separately under 1862 when we go to limited partnership. And again, one of the rights of the partners, as we mentioned already before, is the one under Article 1785. And to refresh your memory, 1785 talks about the conversion of a specific a partnership for a fixed term or a specific undertaking. It is converted to a general partnership at will if the partners continue. And as we've mentioned, the rights and obligations of the partners under the partnership for a fixed term continues to be the same rights of the partners once it is converted to a partnership at will. So that's also another right. I just added it there, but we already discussed this in the first video. So this is the provision that I was talking about. Okay. Now let's move on to the partner's obligations. And counting the provisions, there are 9. The first one is under 1786. Every partner is a debtor of the partnership for whatever he may have promised to contribute thereto. He shall also be bound for warranty in case of eviction with regard to specific and determinate things which he may have contributed to the partnership. So this principle of warranty in case of eviction is similar under the law on sales, and I will discuss this later. He shall also be liable for the fruits thereof from the time they should have been delivered without the need of any demand. So the reason why there is this last sentence is because usually a debtor is liable for interest from the time of demand. So this is an exception. Here, there's no more need for demand. And this is in harmony with Article 1788, which we will flash later on, particularly paragraph 1, where it says that a partner who has undertaken to contribute a sum of money and fails to do so becomes a debtor for the interest and damages from the time he should have complied with his obligation. So there's no need for demand. The reason for this rule is because the contributions become the property of the partnership. So the partner becomes the debtor because he or she must deliver the property which now belongs to the partnership. Now, in the absence of an agreement as to what will be contributed, the promise is to make an equal contribution of the partnership, and this is under Article 1790. Now, let me explain more about eviction. Now, this is covered by the law on sales under Article 1548. Eviction happens whenever by final judgment based on a right prior to the sale or an act imputable to the vendor, the vendee is deprived of the whole or a part of the thing purchased. So, for example, O, the owner, let's just call him O, authorized A, the agent, to sell O's lot. O is later able to sell it to B1 and immediately notifies A, agent. But when A received notice that O already sold it, A already sold the land to B2. So, who registered the sale before B1 registered his? Now, under sales of real property, it is actually registration which operates as constructive notice to the world. So, even if B2 purchased the property from A after B1 bought the property from O, since B2 was the one who registered it, B2 would have a greater right over the property. So, B1 can be evicted. In this case, if that happens to the partnership, the partner, in that case O, can be bound for warranty against the partnership. I hope that makes sense. So, additional obligations, aside from the obligation to deliver what he promised to contribute, and the obligation to be bound for warranty in case the partnership is evicted from the real property that the partner contributed, or to evicted for specific indeterminate things. And aside from the partner's liability for the fruits, a partner is also obliged to preserve the property with the diligence of a good father of a family, if you remember your law on obligations under Article 1163. And as mentioned already, under Article 1788, the partner is also required or obliged to indemnify the partnership for any damage caused if there is a delay in the delivery of the contribution. What would be the remedy of the partnership if the partner fails to contribute? The remedy would be to sue for specific performance with damages and interest, meaning to go to court and to tell the court to force the partner to contribute what he promised to contribute. Or number two, to ask for rescission or annulment of the contract if there is fraud or misrepresentation. And this is covered under Article 1838, which we will discuss under dissolution for week 3. Now, rescission or annulment of the contract is usually in cases of an empty promise, meaning A, B, and C entered into a partnership where A promised to contribute 100,000 with the agreement to divide the profit 3 ways. So, in the middle of the partnership, A keeps saying, yeah, I'll give the 100,000, I'll give the 100,000. Yun pala, A really didn't have any plans to contribute. Then, the partners, instead of seeking for specific performance because it would be an exercise in futility, meaning it would be useless to do so, A had really no plans of contributing, they can seek rescission or annulment of the contract. Okay. So, as I've mentioned already under Article 1788, a partner who has undertaken to contribute a sum of money and fails to do so becomes a debtor for the interest and damages from the time he should have complied with his obligation. The same rule applies to any amount he may have taken from the partnership coffers, and his liability shall begin from the time he converted the amount to his own use. So, the partner's liability to pay interest and damages should have been either from the time that he should have complied, no more need for demand, or from the time he converted, not from the time that it was discovered he misappropriated it. So, what is the need for this particular provision. This is an exception to the general rule under Article 2209 of the Civil Code, and Article 2209 talks about damages. Under Article 2209, if I may just quickly explain, it says here, if the obligation consists in the payment of a sum of money and the debtor incurs delay, the indemnity for damages, there being no agreement to the contrary, shall be the payment of interest. Therefore, under Article 2209, damages is interest. But 1788 says no, damages and interest are different. Now, how much would damages be? That would depend on the agreement of the parties. And they're free to decide how much it would be. Article 1790. Unless there is a stipulation to the contrary, the partners shall contribute equal shares to the capital of the partnership. And this has already been discussed earlier. So this is the general rule. Now, just be careful with 1790 because this also applies to industrial capital partners, not just to capitalist partners alone. The next obligation is Article 1806. Partners shall render on demand true and full information of all things affecting the partnership to any partner, a legal representative of any deceased partner, or a legal representative of any partner under legal disability. Now, I discussed this along with Article 1821 because 1806 talks about a partner's duty or obligation to render a true and full information of all things about the partnership to another partner. 1821 also talks about a partner's duty to inform the acting partner of any knowledge that comes to his or her mind that he or she should have told that acting partner. Let's go back to 1806. A partner's requirement to render on demand is true and full information of all things affecting the partnership to another partner or to a partner's legal representative does not include information that appears in partnership books. Why? Because that partner or that legal representative can exercise that right under 1805. What is the need for 1806 then? It's because a partnership is a fiduciary relationship. There is a need for transparency like a romantic relationship. So, that's why De Leon says there are certain circumstances where one is under a duty to voluntarily disclose material facts, meaning facts that are not in the books. For example, in a buy and sell of printers, they're right behind me, A, B, and C company has a particular client, say De La Salle University, who buys printers from A, B, and C company. Now, since DLSU is a big school, let's assume that DLSU is their biggest client and 90% of their sales come from DLSU. If, for example, A suddenly heard from the grapevine or heard from gossip that DLSU is being courted by X, Y, and Z company, so that DLSU will buy from X, Y, and Z, it's not in the books. So technically, the other partners will not know about this. But under Article 1806, A should disclose all things that may affect the partnership. How will that affect the partnership? If ever DLSU does decide to buy printers from X, Y, and Z, A, B, and C company will effectively lose business because DLSU is 90% of its sales. So another obligation. Under Article 1793, a partner who has received in whole or in part his share of a partnership credit when the other partners have not collected theirs shall be obliged, if the debtor should thereafter become insolvent, to bring to the partnership capital what he received, even though he may have given receipt for his share only. This is different from Article 1792. What is 1792? 1792, if you remember what we discussed in the first video, talks about a case where a partner collects a demandable sum from another person who owes the partner and the partnership. If you remember that, if you remember our example where X owed A and the partnership 100,000 and 200,000 pesos respectively, and X only had 60,000 pesos. And so, if you remember that, that provision talks about one credit. 1793 is different. This talks about a partnership credit, meaning in a case where X approaches A and says, excuse me, A, this is I only have 60,000 and I owe the partnership only. X does not owe A. I owe the partnership 200,000. Please accept this as my partial payment. If, for example, A gets the money and says, okay, well, I'll just get this in advance. This is my share anyway, since B and C will have their own share of the 200,000 when X pays later on. If in the event that X later becomes insolvent and cannot pay the 140,000 balance, then A would have to return the 60,000 he got. That's all that 1793 says. This is because all partners must share in the loss. Without this provision, what can happen is that A will just say, no, this is my share so I won't return it na. Kawawa naman B and C, who didn't get any share from the 200,000 bad debt, diba? They should have apportioned it accordingly between the three of them. Next obligation. Article 1807. Every partner must account to the partnership for any benefit and hold as trustee for it any profits received by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership or from any use by him of its property. So this provision talks about secret commission or similar profits. For example, a managing partner in the case of ABC company that sells printers to De La Salle and others, if A is the managing partner and knows that there's a cheaper supplier, A then later goes to La Salle and says, I'll sell it na lang to you for half the price that our partnership sells it because I now have a new supplier. In that case, 1807 says, even if you sold it under your own name, you must account whatever you earned from that sideline because it's supposed to be the income of the partnership. It will be considered a transaction connected with the business because of course ABC company is in the business of selling printers. Another example, because that example involved fraud, no? In that sense, because A did not disclose to the partnership that he found a cheaper supplier because A wanted to pocket the money for himself. There's also, it does not necessarily mean that this only contemplates cases of fraud. It can also be a case where irrelevant to the pandemic. If, for example, A, B, and C has a partnership wherein they purchased motorcycles to be used for Grab, and then the pandemic hit. So, if you remember back in March when the coronavirus was starting to spread rapidly, we were on ECQ. So, we were on lockdown. Even services such as Grab, Lala Move, Mr. Speedy stopped because they couldn't go out. In that case, if for example, since the managing partner has contacts or the managing partner was able to get an exemption so that a particular driver can do errands, say, to deliver to hospitals yung mga masks. If you remember, during the ECQ, there were a lot of donation drives. So someone had to transport them given that they got a government pass or an IATF. So in that example, if A was able to get the if A was able to get an exemption and was able to use the motorcycle of the partnership to deliver, then he will have to account for the profit, even if he did not mean to defraud the partnership. Another example would be a case decided by the Supreme Court. In Catalan versus Gatchalian, this is a case where A and B were partners who operated a theater in Tacloban City. Needing funds, the partnership mortgaged to C a lot covered by another title in the name of the partnership. Because of the failure of the partnership to pay the loan, C foreclosed the mortgage. And as a result, it was sold at a public auction. And the one who became the winning bidder was C, the creditor. So, a few days before the expiration of the a few days before the expiration of the 1-year period of redemption, A redeemed the property with his own private funds, and then A sought to have the title transferred to his name because he redeemed the property of the partnership. Now, the question was whether A could do that. The Supreme Court, although it was a decision covering other topics, mainly said that every partner becomes a trustee for his co-partner with regard to any benefit or profit derived under Article 1807. This means that although there was no profit in a sense that there was no sale, because of A's redemption, the property was saved. That's why 1807 operates, because it talks about any benefit, not just profits. Another obligation is the one under Article 1791. If there is no agreement to the contrary in case of an imminent loss of the business of the partnership, any partner who refuses to contribute an additional share to the capital, except an industrial partner, to save the venture shall be obliged to sell his interest to the other partners. This was already discussed in the first video, so I don't need to discuss it anymore. Just take note that there can be an agreement to the contrary. So 1791 only operates, meaning the obligation to sell your share to the other partners will only happen if, number one, there is no agreement to the contrary. Number two, there is an agreement by a majority of the partners that there is a need to contribute additional capital to save the business. So that just take note of that. The next obligation would be Article 1789. An industrial partner cannot engage in business for himself unless the partnership expressly permits him to do so. And if he should do so, if he does so without the express permission of the other partners, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision, with a right to damages in either case. So, what are the things that need to be noted? An industrial partner cannot engage in any business for himself unless there is an express permission to do so. And number two, if he violates that rule, there are two options by the other partners. Number one, they can remove him from the firm. Or number two, they can avail themselves of the benefits which he may have obtained. What benefits are these? Usually, whatever the industrial partner earned from that other business, the other partners can get. In either case, whether they remove him or they get the benefits that that industrial partner got from the other business, they have, on top of those two remedies, the right to damages. Take note that this sentence says, if he should do so, the capitalist partners may either exclude him from the firm. It should not only refer to capitalist partners, it should refer to all the other partners. Because, for example, if there is a partnership between A, B, C, D, and E, if D and E were industrial partners, and E was the one who engaged in another business, then D, as an industrial partner who is innocent, should also be included in the remedy to avail of the benefits that E got, no? Not just A, B, and C. Does express permission need to be written? The law is silent. I think it's not, by express permission does not necessarily need to be in writing, but it would be best to do so, because if it were just a verbal express permission, then it's very easy to deny that later on. So what's the reason for this rule? It's because an industrial partner's contribution to the partnership is his services. And therefore, since a partner's contribution becomes the property of the partnership, it's like saying that the partnership has exclusive right over the industrial partner's work or industry. And his industry or his services to another business can actually be considered prejudicial to the interest of the other partners. Now, we discussed this with Article 1808. The capitalist partners cannot engage for their own account in any operation which is the kind of business in which the partnership is engaged, unless there is a stipulation to the contrary. Any capitalist partner violating this prohibition shall bring to the common funds any profits accruing to him from his transaction, and shall personally bear all the losses. So if you compare the two, 1789 and this provision 1808, industrial partners are not allowed to engage in any form of business unless expressly agreed. On the other hand, for capitalist partners, this prohibition is only relative, meaning they are not allowed to engage in an operation which is of the same kind as that of the partnership. What if the capitalist partner engages in a similar business but for someone else? For example, ABC company in the sale of printers. He cannot enter into a similar business. But what if he does, but not for his personal benefit, but for the benefit of X? Say X got him as a consultant, said, A, you're really good at looking at the specs of the printers, you know where to get, can you help me set up my own business? Although it's not stated here, because this provision talks about engaging for their own account, I think it should also be part of the prohibition. Again, because what one cannot do indirectly, what one is not allowed to do directly, you cannot do indirectly. Why is that? If X got A as a consultant, isn't it obvious that X will pay A for his services and his expertise? Diba? So that should also be for the account of the partnership. Now, there's an example I saw in another book that I used to read when I was in law school. I'd like to share it with you. Jinggoy and Philip formed a partnership to operate a car repair shop in Quezon City. Jinggoy provided the capital, while Philip contributed his labor and industry. On one side of their shop, Jinggoy opened and operated a coffee shop, while on the side, Philip put up a car accessory store. May they engage in such separate businesses? Why? This was actually asked in the 2001 bar. The answer is Jinggoy, the capitalist partner, may engage in the restaurant business because it is not the same kind of business as the partnership is engaged in, which is car repair. However, Philip may not engage in any other business unless their partnership expressly permits him to do so, because Philip is an industrial partner. So he has to devote his full time in the business of the partnership. Okay. Now that we've done the partner's obligations, let's go to the partner's liabilities. Under Article 1816, which should be discussed with Article 1822, 1816 says that all partners, including industrial ones, shall be liable pro rata with all their property after all the partnership assets have been exhausted. for the contracts which may have been entered into in the name and for the account of the partnership under its signature and by a person authorized to act for the partnership. However, any partner may enter into a separate obligation to perform a partnership contract. This provision talks about a partner's liability for the contractual obligations of a partnership. Take note that 1816 refers to all partners including industrial ones. So you might be thinking, teka lang, isn't an industrial partner exempted from sharing in the losses? Yes, that's true. But 1816 talks about liabilities. Meaning, when you say pro rata, if I may explain briefly, pro rata means equally according to their share, not solidarily. So if A and B are capitalist partners, and let me just open my notepad for easy reference. There. If A and B are capitalist partners, and C is an industrial partner, A and B contributed 10,000 each. Now, to the partnership. However, the partnership contracted a liability of 26,000 in favor of D. Under Article 1816, D can sue the firm and all the partners, including C, for the remaining, because of this, there would still be a liability to D, for 6,000. Now, how will you apportion that? When you say A, B, and C are liable pro rata, that would mean that A needs to contribute, A needs to pay the creditor another 2,000, B for 2,000, and C, even though he is an industrial partner, for 2,000 as well. However, after paying 2,000, C can now seek to get the 2,000 from B and A, because this is an agreement between them. This is different from their loan to a third party for 6,000. Why can C get from A and B, but C cannot exempt himself from the 6,000 loan to D? It's simple. Because this one, the one in red, talks about the liability to a third person. However, the one in blue talks about losses. And since C can be exempted from any loss, therefore, he can ask that he be reimbursed for that amount. Now, if in the same example, the capital contributions of the partners were different, A and B contributed 15,000 and 5,000, not 10,000 each. Then, the 6,000, the share in the loss, let's talk about loss not liability, because the liability will still be the same. They will still be required to contribute to the creditor to 2,000 each. But when it comes to the losses, it will be, hold on, excuse me. That's confusing. A are still required to pay 2,000 each. But in terms of the loss, just erase this. But in terms of losses, excuse me. Oh, I made a mistake. But in terms of losses, A now having 3/4 will shoulder 4,500 total, and B will now shoulder 1,500 total. Oh. What does it mean? B now can also seek to be reimbursed by A for 500 because B shelled out 2,000, but he shall only shoulder a total loss of 1,500. So let's continue. Under Article 1817, any stipulation against the liability laid down in the preceding article, meaning the one we just discussed, shall be void except as among the partners. Meaning, if there is an agreement which states that C, the industrial partner in the example that I just gave, C will not be liable to the partnership's creditors in case of insolvency, that would not be allowed. The creditor, say D, can still collect the 2,000 from C, the one I just wrote down in the notepad, no? But that agreement will be valid between A, B, and C. So that's all that 1817 says. Now, 1816 talks about contractual obligations. What about the liabilities of the partners when it comes to criminal actions or quasi-delicts? Quasi-delicts is negligence, torts, things that are short of criminal offenses. Now, the purpose of Article 1817, where any stipulation against the liability laid down in the preceding article shall be void except as among partners, becomes more relevant when we are talking about partners that are all capitalist. So, in this case, 1799 disallows exemption from losses. If you remember, a stipulation where any partner will be exempt from losses is void, except for industrial partners. Meaning, even if there is a stipulation exempting them from liability, do not be confused that this one does not contemplate losses. It simply means that you cannot use your exemption to avoid paying third persons. But since it is valid and enforceable among the partners, you can seek reimbursement from others. So, under Soriano, he gives a good example I'd like to share. And I'll open my notepad for that. Okay. So, it's a bit complicated, so please bear with me. Calixto, Hebron, Austria, Rojas, and Mendez are partners in the firm Charm Sales Company. Thankfully, Soriano uses the first letters to form the partnership name. Calixto is an industrial partner while the rest are capitalist partners, with Hebron contributing 20,000, Austria contributing 30,000, Rojas contributing 10,000, and Mendez contributing 40,000. So this is a total of 100,000. Yeah. The partners stipulated that Hebron shall not be liable for liabilities of the partnership after its assets are exhausted. So, under the agreement, that Hebron is not liable for liabilities. After several years of operational losses, Charm's assets dwindled to 120,000 while its liabilities reached 160,000. So, if ever Charm has assets of, what did I say? 120, and liabilities of 160, that means the equity would be a negative 40, which will be shouldered by the partners. How shall the liabilities be paid? As we mentioned, the assets will first shoulder the liabilities. So there will be a balance of 40,000. The 40,000 shall be shared equally by the 5 partners at 8,000 each. And it shall be paid out of their separate assets because of course they need to pay creditors. So that 4,000 will be divided into 8,000 per person. So 8,000 here. There. But based on the ratio of the capital contributions of partners, where Austria, Rojas, and Mendez shall share in, if you apply the provision under Article 1817, if you say it is valid and enforceable among the partners, it means that that Hebron can now seek reimbursement for the 8,000. Automatically, Charm will seek for reimbursement. Now, H will also seek for reimbursement because it's already agreed that he will not be answerable for liabilities once the partnership assets are exhausted. So, how will this be computed? What will happen here is that you will have to compute based on their contributions. Since the ones who will shoulder are Austria, AR&M, Austria, Rojas, and Mendez. Their ratios will be 3:1:4. Okay? Now, the 40,000 will now be divided using that 3:4:1 ratio. Therefore, if you compute it, and I'm sure you're really good at this and you're better than I am, Austria will now have to shoulder a loss of 15,000. Rojas will now have to share a loss of 5,000. And Mendez will now have to share a loss of 20,000. Computed as 40,000 times 3 divided by 8 for Austria, 40,000 times 1 divided by 8 for Rojas, and 40,000 times 4 divided by 8 for Mendez. Now that we know how much they will share, you will now see that Rojas also made an overpayment of 8,000. So now he can claim 3,000. And Mendez has an underpayment of 12,000. Kulang pa siya. He still needs to pay. Austria also has an underpayment of 7,000. Whereas these two now have an overpayment of 8,000. And that's how they will now work it out, how they will pay each other. That's an example of how 1817 is implemented. So, what's important here? When you say that Hedron is exempted from liabilities, it only means that once his share of the capital contribution of 20,000 is already used, you cannot ask him to make an additional contribution, and that's valid because it's an agreement between the partners. However, it does not mean that he will absolutely be not liable for any losses. If you remember, under Article 1799, any stipulation exempting a partner from losses is void. This is a case where he did suffer a loss. He lost his 20,000 investment, but the agreement that he will not be liable for more is valid. What is not allowed is he he will have the right to be reimbursed for the 20,000 initial payment he made and the 8,000 that he paid. That would in effect be a violation of 1799. I hope that makes sense. Please do message me if you need me to explain again. Yan. Let me make a point of clarification under Article 1817, where any stipulation against the liability is void except as among the partners. So when you implement 1817, it simply means that a partner the sharing of the partnership's liabilities to third persons is pro rata and subsidiary, meaning you should first exhaust the partnership assets before you go after the personal assets of the partners. Number two, this sharing is only for general partners because, as we will discuss later on, limited partners will not be liable for partnership liabilities using their own personal property. And number three, if there is a stipulation exempting a partner, it's void to others but valid amongst themselves. However, as I've mentioned earlier, like in the case of Hedron, the partner's capital contributions are not subject to reimbursement because if it were, then it would be a violation of 1799, which disallows a partner from being exempt from losses. So what will happen is the partnership assets first, then equally from separate assets of the partners, and then the partners, the industrial and the limited partners can, and those other partners who are who stipulated will be exempted, will be reimbursed. Ang uunahin muna, or the ones who will be reimbursed first, are the industrial partners, and then the others. So let me discuss 1816 along with 1822. 1822 says that whereby any wrongful act or omission of any partner acting in the ordinary course of the business of the partnership or with the authority of his co-partners, loss or injury is caused to any person not being a partner in the partnership, or any penalty is incurred, the partnership is liable therefore to the same extent as the partner so acting or omitting to act. This case talks about criminal or quasi-criminal liability or a quasi-delict. Quasi-delict means, as I've already mentioned earlier, it talks about negligence or torts. Acts short of a criminal liability. A criminal act, excuse me. So, why do we discuss these two together? It's because under Article 1816 discussed just before this, talks about contractual liabilities. The liabilities of the partners are pro rata and subsidiary. Meaning, under Article 1816, for contractual obligations, the partners are only liable to the partnership's creditors after exhausting the partnership's assets. That's subsidiary. Pro rata because it's share and share alike. They will be sharing that equally. However, under Article 1822, this involves criminal liabilities and their liability is solidarily. Why do I say solidarily? Because it says here that the partnership is liable to the same extent as the partner. Meaning, you can seek payment from both the errant partner and the partnership for the same amount. So let's clarify this. De Leon gives a good there is a statement here in De Leon for those who are reading his book where it said here under page 115, he made an example. If the for example, the partners are liable for the negligent operation of a vehicle by a partner if that partner is acting in the course of business which results in a traffic accident. And that's correct because that is contemplated under 1822. Because it said there, any wrongful act or omission of any partner acting in the ordinary course of business. So, for example, in the car, no? We just mentioned traffic accident. But, says De Leon, but if he is driving a partnership-owned vehicle for purposes of his own, although with the permission of the other partners, the acting partner alone is liable. I think this is wrong because it says here that the partnership is liable even for those that are not part of the business, that are not in the ordinary course of business, as long as it has the authority of his co-partners. So just take note of that. Meaning, that's why in the same page of De Leon, he correctly stated the requisites under 1822. Number 1, the partner must be guilty of a wrongful act or omission. And number 2, that wrongful partner is acting either in the ordinary course of business or with the authority of his co-partners, even if the act is not connected with the business. So please take note of that. Just in case you're reading De Leon's book, the paragraph right after those requisites is wrong. Well, at least in my opinion. Please do correct me if I'm wrong, as I am open to these types of corrections. Okay, the next liability would be under Article 1826. A partner admitted as a partner into an existing partnership is liable for all the obligations of the partnership arising before his admission as though he had been a partner when such obligations were incurred, except that this liability shall be satisfied only out of partnership property unless there is a stipulation to the contrary. So 1826 contemplates a situation where there is an incoming partner that arrives after. So here, he will say, for example, in a partnership between matches A and B. Say for example, A and B entered into a partnership in 2020 and C joins them in 2021. So what happens is C will be for example, if I may add, they each contribute 100 pesos. They're only matches, so they should be cheap. So if C enters into the partnership in 2021, she will be liable for all the obligations of the partnership arising before she arrived, meaning all the obligations since 2020, as if she were a partner then, except it's only out of partner, that this liability shall be satisfied only out of partnership property. That means that C's 100 pesos can be used to answer for any liability of the partnership in 2020. Therefore, if her 100 pesos is still not enough, C should not be required to pay more for liabilities incurred in 2020. So let me clarify. For liabilities incurred from 2021 onwards, C will be like any partner, meaning she will be liable for partnerships liabilities incurred in 2021, even for those past her capital contribution of 100. So in an example by De Leon of the same article, and if I may just add this for clarification purposes, A, B, and C are partners engaged in a drugstore business. Their contribution is 10,000 each. D is admitted as a new partner with a contribution of 4,000. So let me put this here in a different color. At the time of his admission, the partnership has an outstanding obligation to D in the amount of 40,000. So D as the creditor, as the partnership creditor. What happens now is that the assets of the partnership amounting to 34,000, this is a total of 34,000, will be used to pay the 40,000. So 40,000 minus 34,000, there will still be a remaining balance of 6,000. This 6,000 will now be taken from the personal property of the partners. But since we are talking about the liability to E that was contracted before D arrived, D should not be made to pay using his or her personal property for the 6,000. This will now be divided between A, B, and C, pro rata. Therefore, they will be made to pay 2,000 each. Excuse me. Okay. However, if the liability was incurred after D was admitted into the partnership, then it would be a different ball game. Now, D would also be made to pay. And since it's pro rata, they will each have to pay E 1,500. De Leon then goes a step further, just to explain for those who are reading the book, that after, if in the case of the 40,000 to E was contracted after D entered into the partnership, of course, and there is no agreement as to how profits and losses will be shared between the partners. If you remember the previous stipulation under the law, there is no particular agreement, then they will share in accordance with their capital contributions. So, if I may take it another step forward so that we can integrate some of the provisions that we discussed earlier, what will happen now is that this 6,000 loss, this is now a loss between the partners. They will now share it in accordance with their capital contributions. So how will it be divided? A, B, and C's A, B, and C will now be shouldering 10 over 34. 10 over 34. I hope everyone follows. I'm sure you're very quick, as I have not done any accounting in the past 12 years. 8 years pala, sorry. So what happens is the 1034 of 6,000, excuse me, A, B, and C will now share 1,000, I'll use another color, will now shoulder 1,764.70 of the loss. Because this is in proportion to their capital contribution. Again, I will repeat, this is under the assumption that there is no agreement as to the profit and loss sharing. And then D will now shoulder 705.88 of the loss. So now, A, B, and C will now have to give D 264.70 each, just so that it will balance here. I hope that's clear. If anyone needs to ask, please feel free, and we will have an asynchronous class soon for this. I will message. Okay, so let's go back to the PowerPoint. Remember, there can always be a stipulation to the contrary, meaning even if in this case, even if C is a new partner, if they agree that upon the arrival of C, she will be liable for past obligations to the extent of her separate property, then that's valid. Another example is when C, another example of the stipulation to the contrary under Article 1826 is if C arrives and assumes the obligations of B. See, for example, B wants out. And C says, okay, I'll come in, I'll answer for everything. I'll assume the obligation of B. That's also another example. Moving on to another liability. Every partner is responsible to the partnership for damages suffered by it through his fault, and he cannot compensate them with the profits and benefits which he may have earned for the partnership by his industry. However, the courts may equitably lessen this responsibility if through the partner's extraordinary efforts in other activities of the partnership, unusual profits have been realized. So, 1794 talks about partners' responsibility or liability for damages suffered through his fault. So, this is called the no set off provision. I'll write it down. Why? Because when you say set off or compensation, if you remember your law on obligations, compensation occurs when two parties are debtors and creditors of each other. This is not so in partnership because a partner is not a creditor of the partnership anyway. Enough so that if he owes the partnership for whatever fault, you can compensate. That can't happen because again, the partner is not a creditor of the partnership. This is also in harmony with Article 1170, where any person guilty of negligence or fraud in the fulfillment of his obligation shall be liable for damages. Now, let's talk about the court's role. The courts may equitably lessen this responsibility. When you say reduction, this is not a mere mathematical computation. Take note, although it's not so important, the court will now decide, based on the circumstances of the case, how much would be an equitable reduction of the partner's responsibility. When you say equitably lessen, it means that I think the court should not completely exculpate or exempt the partner at fault. So take note, it's equitably lessened. It doesn't say that the courts may exonerate him or clear him completely. And only if in case that errant partner exerted extraordinary effort that resulted in unusual profits. So while we will discuss this under the liabilities of the partnership also, I would like to take note that this also talks about the liability of the partners for, number 1, misapplication by a partner who acts within the scope of his apparent authority. And number 2, where a partner misapplies it while it is in the custody of the partnership. There. So this talks about breach of trust. Yeah. So these are the liabilities of the partners. And this ends the second video. So I'll see you in the third.